So I'm the former counsel of Mr. Hess, and I was served with documents, but I put in a withdrawal. I don't know if my client's been served with a motion for contempt or not. So I think this matter needs to be.
I did make a note of that. Do we have Miss Tangen here?
I see one of the windows says Chelsea Tangen or Tangen.
Let's see if they will unmute. Chelsea Tangen.
There's
Yes, I'm here. Sorry about that.
That's okay. So I noticed that there was service to the attorney, but that attorney is no longer representing Mr. Hess. And it looks like Mr. Anagnostou tried to share that information with him to the last known address. But I don't know if, since he's no longer represented, what probably would be the best course of action. And how do you say your last name so I don't keep messing it up?
Mine?
Yes.
Chelsea Tangen.
Tangen. Okay. So Ms. Tangen, what I think the best course of action may be is to try to serve him personally since he no longer has an attorney and then note it back onto the docket.
So we've been in contact with our child support worker, and he was aware as of several weeks ago about this court date and the time. And he did get the documentation from his attorney.
And so that's great. I just don't have any proof that he was served. So I don't want to, I would love to just take your word for it. But if I did that, then everybody else would expect me to just take their word for it that somebody knows about a court date and chose to not show up. I'm happy to set it over 2 weeks to see if you can provide service. And if he doesn't show up at that point, we can set it to the 26th of December at 1 p.m. And if you can provide proof of service in that time, we can handle it on the 26th.
Yeah, let's do that. The 26th.
Okay. And if for some reason you agree to a different date, you can set it to a different date. That's just what I have available to offer you. So you don't have to kind of start all over again. You would just need to provide proof of service.
So I do have a question.
Sure.
Oh, because this whole time he's had an attorney. So how it's worked is we've served the attorney. So I guess I'm confused. So do I serve Mr. Anagnostou because we got a letter stating that he's no longer the attorney as of November 28th? Or am I supposed to serve Jeremy myself because he also lives 6 hours away from me?
He needs to be served. Mr. Hess needs to be served. I can't give you a legal advice. You can't personally serve him unless there was a previous agreement to that. And I don't know if there was a previous agreement to any service by email or other forms, but you could have a private individual or a process server serve him wherever he's residing.
Okay. Thank you.
All right. Good luck. And I will set this to the 29th. If you do a service and note it on for a different docket, that's totally okay. It's up to you, but at least that'll be a court date sort of in reserve for you.
So sorry, I thought you said the 26th.
Did I? Yes, I did say the 26th, and then I said the 29th. I meant the 26th.
And then do you know what time that will be?
1 p.m.
And okay, thank you.
Sure, thank you. GAL review.
Correct. And on behalf of Joseph Deal, Judge, we did get the GAL report late last week. So I think the train is on the tracks, and we're good to start setting some dates with hopeful mediation to see if we can get this resolved sooner as opposed to later. I've been in touch with Miss Jocelyn, who I don't see on my screen, but nonetheless, oh, there she is. But nonetheless, I think that's where we're at right now. Keep the status quo and hopefully move towards a resolution sooner than later.
All right, Miss Jocelyn, anything to add?
Yes, Your Honor, agreed. The only thing to add is we are hoping to keep Miss Turnbull on because my client is in the process of moving back, and there was some talks potentially, this would be a trial issue. If she does move back, that the report could potentially be different. So we'd rather not have to reappoint her, just have her on. And so when my client does move back, she can do an addendum. And if Mr. Zandy and I can't agree, we have our trial date set.
Any concern with that, Mr. Zandy?
Yeah, I can't really comment on that. And maybe it was in prior pleadings and I just missed it or have forgotten, but I don't recall there being any conversation about Miss Cole moving back to the local area. I'm not sure that would constitute a change in circumstance. I have no issue if Miss Turnbull remains as the GAL, but that's kind of where we're at. I guess predicting the future is probably not appropriate at this point on whether she moves back or she doesn't, or what the impact is on the kids. I would just assume we keep this simple for now. Either party can come back upon a change in circumstance if they think that's appropriate. But where we sit today, I think just keeping this streamlined is probably the most prudent thing to do.
And my clients had a job interview yesterday for the local area. Has already talked to a mortgage lender. So, I mean, I guess it's 6 of 1, half dozen, as long as Ms. Turnbull stays on and can draft an addendum. You know, she's looking in the next 3 or so months. She should be here. We just didn't want to have to note it up for a brand new GAL report since Ms. Turnbull's familiar. Turnbull, sorry, I keep saying ball. I apologize.
I think if there's a request for that, and it's not agreed, I'm going to ask that it be noted up. Generally, the GALs are discharged when their report's done, barring any trial. But if there's a specific request for a new investigation, given a certain change in circumstances, and Mr. Zandy doesn't agree, I would ask that be noted up. But I would obviously agree that Ms. Turnbull be appointed on that, since we wouldn't want to have to start fresh. So
thank you, Your Honor.
And all right,
thank you.
Ms. Winkler.
Thank you.
Oh,
thank you.
I was just going to say, do you mind if I turn off? I broke my jaw, so do you mind if I turn off my camera so that it's not like I'm not seeing myself?
That's fine. That's fine.
Thank you.
Mr. Zandy, hold on, Ms. Winkles. I'm just gonna, Mr. Zandy. It looks like Mr. Hitchcock is present. So, and he's now connected to audio. So, Mr. Hitchcock.
Yeah.
Hi, we just called your case. I didn't see you here, but I see you here now. There was an order that was presented by Mr. Zandy, basically saying that you need to turn over the report.
Yeah.
So it basically says what I ordered at the last hearing, but instead of the report being due last Friday, we're having it due this Friday. So because it sounded like you were having, Mr. Zandy indicated that you were having a few difficulties with that. So I didn't want to enter an order that wouldn't work. So any questions about that?
I did email Dr. Maharg Thursday and Friday. He didn't get back to me. I believe that did Mr. Zandy have a subpoena that he submitted to the court?
I don't recall any subpoena. I mean, I know that there was
that. No, we wouldn't have subpoenaed the court for anything. We subpoenaed Dr. Maharg to get said report, at which time Dr. Maharg indicated that he would prefer to have a court order, given some of his issues with Mr. Hitchcock signing release of information. So that prompted the motion. So we now have a subpoena that's outstanding, as well as the order which Dr. Maharg preferred. So
yeah, he wanted a subpoena that was signed by the judge, so if we could have the judge sign it to release the records to Ann Hite and Mr. Zandy, that would be, I think, advantageous. I mean, if I can only email him so many times.
That's all he has to do, Judge, is my understanding, is go to Northwest Psychological, say I'm going to pull my restriction on the release of information, and go ahead and release that. He doesn't need to talk to Dr. Maharg about that. He just has to go over there and do that with Northwest Psych. So again, this is kind of the gamesmanship that we've been unfortunately subjected to over the last 17 months, patiently waiting for this published time and time again. So that's all he's got to do.
So the order, Mr. Hitchcock, basically says that it needs to be provided to the court. That should be more than sufficient for Dr. Maharg to turn over the report. Additionally, at the last hearing, there was an indication that you essentially revoked the ROI. And that's part of why Dr. Maharg didn't want to release the information, because he didn't have your permission to do so. And that's why he wanted an order. So we now have an order. I've signed that order. You can get a copy of it from the clerk and you can take it over there, or you can just pull your the hold on your ROI and have that information either provided to you and you can provide it to the parties that need it, or ensure that it gets sent to Mr. Zandy. And is it who's the GAL? Miss Hite. Okay.
Yeah. Can you include that in the order to release it to Ann Hite as well as Mr. Zandy?
It's already in there. Immediately made available, provided to the court, which you can file that. and to my office. So I can certainly forward that to Miss Height, or she can pull it off Odyssey on the computer, but she'll certainly get a copy of that.
But it doesn't say to Ann Height. So if it says to Ann Height,
she can get it from the court. Okay. Okay, I've signed that order, so you're up to date. We'll be able to pick that up, I would think, tomorrow, Mr. Hitchcock, if you need it to work with Dr. Maharg's office.
All right, thank you.
I'm gonna. I apologize, Miss Winkles, for calling your case and putting you on hold again. I do have a couple attorneys that are here that are in office without power, and they have limited availability. I got word from Miss Rush before court that power's been out at their office and our phone battery is limited, and it sounds like
we're actually back. We're back up now, but limited.
Back up with limited limitations. Well, it sounds like attorney, Mr. Hunter has indicated that they're without power. So, and I saw him here, and so let's call. I know we're both, or the both of you are here on the. Sorry, I gotta switch tabs here. The Cutler and Cutler. I have to apologize. I was out for the latter part of last week and wasn't able to get a ruling out to the parties because I was ill and couldn't even come into work to grab the stuff that I needed. So I'm prepared to make an oral motion, but if the preference would be to set this over to conserve the little power that you have left, I'm happy to do that as well. So I
think we're okay now, Your Honor. I'm kind of testing out everything here, but we got everything up and running. So I'm good to proceed if Your Honor is, and if Mr. Hunter is.
I am as well, yes.
All right. So thank you again, and my apologies. I did receive all the information that Mr. Hunter provided regarding the bar complaint, and went through all that information. I received the supplemental briefing from Ms. Rush. I reviewed the case law, and essentially where I land is I think that Ms. Rush, her analysis of where this case sits is the accurate rendition of events. I am going to deny the motion to vacate the decision by Commissioner Busby. I do not feel that it falls under bar. I think it's clearly a very unfortunate circumstance. I think it's an interesting posture. There was clearly a lot going on. So I'm going to make a few notes, and I don't know if we want to enter findings, but I will note that there was at the very latest May that Mr. Cutler was made aware by the bar committee that this process would not be a quick one. And we're told that, and he received information essentially from there and from Mr. South about what needed to happen. There was a significant delay in any filing from Mr. Cutler to try to resolve the issues that he felt occurred because of Mr. South's representation or lack thereof of him. We're also in a little bit of a different position because we did go to a full trial hearing. This was not a default. There was a granting of, there was a motion for a default, which was granted, but it wasn't finalized by way of default. It was finalized by way of a trial. Mr. South was present at that trial. I did review the clerk's minutes from that trial. There were several objections made by Mr. South during that trial. So there was some level of participation of him in that process. Clearly, as I stated, I think it's a unfortunate is probably not even a strong enough word of an outcome for Mr. Cutler, as far as relying on his attorney and feeling like there was a relationship there that he could be entrusted to give him relay information, tell him what he needed to do, where he needed to be. I will note also that there was a history of Mr. Cutler's, and some of this I know that Ms. Rush would argue was Mr. Cutler's fault. Some of it may arguably be Mr. South's fault, but a lack of participation in the process. There were some discovery issues and motions to compel that were part of the issue. Ultimately, I think the court heard and reviewed a great deal of information regarding this case and ultimately made a decision. And at this point, I do not feel that as sad as the situation is for Mr. Cutler and Mr. South, I don't feel that there's grounds at this point to vacate that ruling. That segues into the show cause. I am going to deny the show cause for contempt for essentially specific performance. I think while there was some indication that Mr. Cutler was trying to comply at the last minute with some of these requests and make good on the judgment, I think he also was unclear on whether the ultimate determination was valid. So I'm going to find that it wasn't an intentional and willful disregard. I think he was truly seeking out advice and help, and even though it took a while, was eventually intending to move to vacate that dissolution hearing and the results of that. So I'm not going to find that he willfully and intentionally disregarded a specific court order. Clearly.
Can I ask a question on that?
Sure.
So our motion was for contempt and also to kind of enforce the sale of the house. So are you willing to appoint a special master if Mr. Cutler's not willing to sign off on house listing paperwork? Because that was part of our request for relief.
Mr. Hunter, do you want to weigh in on that?
Given the light of what the court's ruling is, let me take that up with my client. I think if we want to maybe set a review hearing on that specific ruling, I'd like the chance to talk that over with him.
We could set a presentation, and I can for the 26th. I don't know if
I'm out that week. So yeah, I would be fine doing presentation and tracking it with this issue, but I'm out the week of the 25th. So
I have presentations on Fridays. So I have this Friday, the 15th at 8:45.
I can make that work if I assume Mr. Hunter's going to draft the order, unless Your Honor wanted me to. It was his motion, but depends.
Whoever can get it done by Friday the 15th, if that's the only day that works. I'm out the 22nd. If you're out the week of the 25th, then
I'm out the 22nd as well to start off that kind of week too.
Okay. The only other, the 5th of January at 8:45 would be the other option.
I mean, I think we might have to take that unless Mr. Hunter thinks he could get the order done by this Friday.
Unfortunately, I'm pretty eager to get things done. Unfortunately, I'm taking care of my 2 kids solo this week. My wife's out of town, so I think it'd be difficult for me to make that work this week.
Okay, so let's just take the January 5th date, and if we can get it done or resolved on anything sooner, we'll let Your Honor know if that works.
If there's an agreement, of course, I'd sign off on anything ex parte. That's fine.
Okay, so that was the 5th at what time was
January 5th at 8:45, and it's just listed as Judge Fassett's presentation docket.
Perfect.
All right, thank you.
And then I do have a request for fees as it relates to the motion to vacate.
I'm going to deny those at this point. Ms. Erickson present now. So as to the 21-7308 matter, this is looks like the presentation of a final order on a parentage determination. Just make sure I have the right numbers with the right things here. Ms. Erickson, did you receive the proposed orders from Ms. Winkles?
No, I have not. I haven't gotten any. I didn't even know about this. I thought we had court on the 19th.
Your Honor, if I may, we've been talking via email. I sent it to the same email that she responded to me this morning on. I sent all the documents.
I haven't seen it.
Okay, hold on.
And we also mailed them to her.
I haven't gotten them. But sorry, I was late on here too. I literally had no idea where I was supposed to go. And I guess I was sitting in the wrong Zoom.
All right. I do show that on the 19th, we have a review hearing for the 23-1508 matter.
And that's with all my stuff, right? That I was supposed to.
And then I have this. Well, it was set on. It was on for Friday morning, December 8th. I was ill, so they set it to today's docket, the 12th. The 8th was set for presentation, is my understanding.
That's correct.
And we have final orders of the parental determination. So that's in the
I was going to submit I seriously thought that we had this court hearing was supposed to be the 19th, and I was going to submit a parenting schedule thing, because you mentioned to me that I could do that, and then I finally am able to get help. And since I don't have an attorney, since he like completely bailed on me, I'm seriously lost, and I haven't felt comfortable enough to really talk with Aaron Nichols, except for when I was dropping off papers. I asked a few questions, but I didn't feel comfortable asking certain questions.
I can understand that this is probably an overwhelming process, and without legal help, it can be very daunting, and I appreciate that. I can't give you legal advice. Ms. Winkles can talk to you directly about some of this because you are unrepresented. There was a summary. I'm still talking. There was a summary judgment granted on January 13th, 2023 in the 21-50007-308 matter. Then that was amended due to a Scrivener's error and re-entered, I think, in October of this year. So we're working off of essentially in this matter, and Ms. Winkles, please correct me if I'm wrong, but essentially just a final parentage order that we need to get entered because of that summary judgment that was frankly entered almost a year ago.
And it should have been entered after, and I'm not sure if it wasn't attached or if it's floating around the court still, but we just submitted it again, essentially the final order, so it wasn't just the the MSJ order, which is kind of temporary in its way.
Right. My daughter doesn't really know Aaron. Like, they're getting to know each other through reunification still.
This basically is an order that says that he's the father.
Oh, okay. I'm sorry. I don't understand anything. I'm sorry.
So as far as that matter goes, this is, I think, probably was just an oversight. I am going to enter the order, essentially a final parentage order indicating that he is the biological father.
And Your Honor, can we also make sure that Ms. Erickson knows exactly what the 19th is, so we don't have to continue or have any other issues with what's going on then?
I'm sorry. I don't mean to.
It should be the entry of final orders after you review whether or not Ms. Erickson has a collateralized mental health evaluation and a drug hair follicle. And then you were going to determine custody at that time for the final parenting plan.
Okay, so because that case that's on the 19th is also on today. That's the 23-30001-508 matter.
And I thought it was actually for today. I didn't know we were on the 19th, so I thought it was all going to be today. But I'm fine with however Your Honor wants to do it.
I called this the court clerk, and they told me the 19th. So like I said, I was trying to get in something that my attorney, I kept asking him to do and he wasn't doing, if that makes sense. And I'm trying to get our $5,000 back to try to find someone to help me on top of everything else.
All right. So we had, long story short, this is my version of my recollection of what occurred. We had a bench trial back in October. And at that point, you were representing yourself. Ms. Winkles was representing Mr. Anderson. There was a lot of information provided by Mr. Anderson, not a lot of information provided by you, Ms. Erickson. The court, and it looks like I was the trial judge, the court allowed some leeway to basically get an evaluation.
Yes.
That the court has not received, and I believe I set a date.
I gave it to Miss Winkles on Friday. I was trying to.
And that's what
Sorry.
I explained, that it's not. And you'll see my emails behind my declaration, Your Honor, that I've submitted to the court. I told Miss Erickson that was not an evaluation; it was not collateralized, and I explained exactly.
I was told that it was.
Hey, Miss Erickson.
Sorry, I'm sorry.
Stop talking over people. No one can hear anything. We've gone through this before. One at a time, please. When someone else is talking, please don't speak. I'll give you an opportunity. I give everyone an opportunity. So please hold on. Ms. Winkles, go ahead.
Yeah, so Miss Erickson did sign an ROI so that I could talk to her counselor. I did speak to him, and he told me that it was an intake and it was not an evaluation. So she came, he hadn't seen her for some months. So she came into the office and I informed her of that. I said, all you need to do is you need to call them, give them, Mr. Anderson's number. They will collateralize and they'll do an evaluation. You need to contact them today. I sent her 3 emails as well telling her that it was not an evaluation. She did not have an evaluation, but she could get one through either Columbia Wellness or Core Health, and that Columbia Wellness would assist her as long as she called within 24 hours. And that's where I left it. I assumed I would get something. I did not get anything, and my client's not been called as of today. So I'm guessing one has not been done. The intake was from last year, I believe, or the beginning of this year.
All right. So since our trial on the 26th of October, Miss Winkles, and I'm not seeing anything in the in Odyssey, but that doesn't mean you didn't receive something. Have you received anything from Miss Erickson regarding a 10-panel hair follicle or a collateralized assessment between October 26, 2023 and today?
So no to the collateral assessment, but I did receive a sheet showing that she had taken a hair follicle. I don't know if, because it was so close to today's date, I don't know if they have the results of that yet. I can actually look because I can log into my system. But the evaluation, no.
All right. And my notes indicate, I'm talking now, Ms. Erickson.
I'm sorry.
My notes indicated that all of that needed to be provided no later than December 8th at 5 p.m. Do you show anything different, Ms. Winkles?
No, that's what I showed as well. And I actually submitted a proposed order to the court from that hearing that stated the same thing.
All right. So Ms. Erickson, it sounds like
May I explain?
I'm asking you a question. My understanding, based on my review of everything, was that you needed to do at least those 2 things: get a collateralized evaluation and a 10-panel hair follicle between October 26th and December 8th. And I don't have either of those things. So please tell me why.
Okay, so so the reason why I have them right here in my hands, I honestly thought that I was supposed to give Erin Winkles hers by the end of her closing time at 5 p.m. And it was already later because what happened was I misplaced, because I already had those done and I gave them to Mr. Roberts. And he was supposed to turn in everything. Come to find out, he turned in nothing at all. So I had copies of it, and all of a sudden I can't find it, right? So I had to actually go to Columbia Wellness myself, and I went and sat there, and while we reprinted off the evaluations and stuff, and one of these pages actually looks a lot different than what I was actually given on my other paperwork, to be honest. They say assessment, and I'm confused because Mrs. Winkles is telling me that, because I did my evaluations as far as I was concerned, and I guess the assessment or whatever isn't it, even though I was told that I did it. I'm so confused over that. But the reason I was going to do my parenting plan, I was getting help because you told me that I could submit one, and I didn't know I could. And I've been waiting and waiting, trying to get help through Northwest Justice and everybody. And I was going to turn everything in today before you guys closed. That was my whole plan. And I thought that we honestly had court on the 19th. I didn't, and I was confused when Miss Winkles, sorry, excuse me. I was confused when she told me, because I gave her a copy of the hair follicle receipt. They didn't have a 10-panel, so I chose to do a 17-panel to kind of go above and beyond and prove that I've been honest. And that should be emailed to Miss Winkles. It should have already been emailed because they said it takes up to 24 hours. And that should have already been done. They wouldn't give it to me directly, even though we're the ones that, like, my dad paid the $350 for. But so I had him sent to I didn't know how to send them to the courts or how to. So I sent them to Miss Winkles in hopes that she would be able to, maybe direct me in some sort of way. Like, that's why I was going to ask her. And then they started looking at my babies, and I just kind of we were talking about my 2 girls, and I completely.
I do have the negative. Just so you're all aware, I do pull it up now. She is negative on everything on the hair panel.
Thank you. I knew. Yep. I have almost 6 years clean and sober. So, okay. So, and then with the parenting plan, I've never done one before, ever. And, that's why I was reaching out for help. I requested that Mr. Roberts help me get one in instead of just agreeing and everything. And he kept telling me, no, we're not going to, that's not what we're doing right now. No, that's not what we're doing right now. And until he told me on September, literally on my daughter's birthday, September 19th, that he was no longer going to be my attorney, is the day that he told me. And then that's when I found out at trial that he never turned in anything that I had submitted him. I gave him everything. I gave him all the copies that I had. I didn't have any copies for myself, and that was stupid of me. But I trusted that he was going to put those in, if that makes sense. And I kind of fooled myself. But I have the paperwork from Columbia Wellness. It's right in front of me. I was just needing help with the parenting plan since I wanted to do one, and he told me that it wasn't the time. Or I have all of his text messages saved.
Okay. I again appreciate the difficulties of navigating this without an attorney, and especially I do recognize that you were at one point represented, and that in September of this year that attorney withdrew, and we did have a trial in October. But I do want to stress that we already had a trial, so there's we can't have several bites at the apple. I gave an opportunity for you to get this information in. I asked that it be turned in by the 8th. It sounds like you have all that information now. We are currently set on the 19th for review. Ms. Winkles, it sounds like, received the hair follicle and that was clean. So that is great news. So thank you, Ms. Erickson, for that. Yeah. I'm not 100% clear that we are where we need to be for that collateralized evaluation. So my understanding, based on the information that Ms. Winkles provided to the court, is that you did an intake, but you didn't do an evaluation. Intakes are not collateralized, meaning they don't get any information from anybody else about an intake. But once they actually do an assessment or an evaluation, that's when they can have collateralized information.
No, I have the assessment right in front of me. I'm sorry.
Well, if it still wouldn't be valid if other parties weren't able to weigh in on it, because that's what was ordered.
Oh no, Aaron's been in there, both of them. I've had them on collateral this entire time.
Ms. Winkles, did your client
no. So this is not true. I spoke to.
He's supposed to call.
Wait, it's one at a time.
Sorry.
Okay.
I'm sorry.
So I spoke to Mr. Sandecker, I believe was his name, who is the person that did it. He stated he hasn't seen her in months. And when she came in, she only did an intake, which everybody does. He stated that she had not done an evaluation at all. And that it had not been collateralized because it was just an intake. And that's what I told her. I even handed her the phone back. And I said, this is an intake. It's not a drug evaluation. You still have time, though. If you call him on the phone and you ask him to do the evaluation, I've just spoken to him on the phone. He's willing to do it. And that was about a week ago.
That was how long ago? I'm sorry.
About a week ago, I'd say.
Okay. All right.
It was Friday or Thursday. I've been speaking.
Here's the problem. I'm done right now. Here's the problem.
I'm sorry.
I'm sorry. It sounds like you're doing what you need to do, but you're doing it at the very last possible moment, and frankly, after the deadline. And I don't have this evaluation. I'm going to absolutely take Ms. Winkle's word for it that the hair panel.
I promise you, I have.
I'm talking right now.
I'm sorry.
We don't, but we had trial on the 26th. All this stuff was due last week. We are on for a review on the 19th. This stuff needs to be into the court and filed and provided to Miss Winkles by the end of today. So by close of business, the clerk's office closes at 4:30 p.m. I would suggest you hang up the phone and immediately come over to the clerk's office, file whatever you have, make sure that Miss Winkles receives it. We're going to be back next Tuesday, the 19th at 1 p.m. to review this case. If I don't have what I asked for 2 months ago, I'm likely going to enter the orders that are presented by Ms. Winkles. She provided proof of service to you. You're claiming you didn't get that stuff.
No.
I would reach out to Ms. Winkles and make sure that you get copies of everything. But it does appear to the court that you've been provided all this information. So
yeah, no. May I ask a question real fast before I annoy you? I'm not trying to.
You're not annoying me. Go ahead.
Okay, I'm sorry. I'm trying not to cry. Sorry, it's emotional. My daughter. Okay, so my SUD and my mental health right here, I'm looking at them right now. Okay, they say assessments on them. They were not intakes, they were assessments. And I gave her the same paperwork that I have right here that I'm going to give to you guys. Do I have to reprint them off and give them to her again? Because I'm confused on that.
I think you can, if you can confirm that you have the same things that you already gave her and that's what you're filing,
yes.
You don't have to give them to her again. But if you have something that she's saying she doesn't have, then you need to make sure that she gets a copy.
Okay, yeah, they Columbia Wellness helped me separate everything for you guys and her. And everything is the same.
Okay. So that needs to be filed so I can review it prior to our review hearing next. And it's going to be a presentation hearing. And that includes any proposed parenting plan that you wish to file, okay?
Okay. I'm in Oregon City right now, so I definitely have to get a move on it. So.
All right. Good luck.
Thank you so much.
All right. We'll see that. And I'll, Ms. Winkles, I'll ask the clerk to hold these papers until next week.
It was
and
Tuesday.
I'll file whatever I have as well.
Tuesday, the 19th at 1 p.m. Yes, ma'am.
Thank you.
That is ready, Your Honor.
And looks like there was a GAL review and Ms. Turnbull is that the one that was emailed?
I don't believe, Ms. Turnbull, you're muted.
Thank you. That was the report for Colin Deal.
Okay. I think I do not have
this. Yeah, I do not have this report finished.
And it's my understanding that she's waiting for the child to be in the area to have a personal contact. It was my understanding.
All right. Yes. Mr. Baldwin, is that your understanding as well?
I wasn't personally aware, Your Honor. I assumed that there was a reason. Given the distance, I'm not surprised. I have no issue sending that piece over. I have had some contact with Ms. Winkles and am hopeful that we are able to work out an agreement as to an in-person visitation. I don't know, Ms. Winkles, whether that weekend was agreed or the sort of process, but I'll defer to you on that.
So my client wants to have a definite in mind today through this court of in-person visitation. So just so Your Honor's aware, he's been having video visitation with the child while she's at the counselor's office. And then the counselor's essentially given us all notes on that. Counselor doesn't engage the child during those. She just monitors and watches. There's been a number of kind of concerning things about some of the things the child knows that child shouldn't know about, but I'm not going to get into that. Essentially, it's time now to move on to in-person visitation where my client goes out and has the child in Utah for the weekend. But my client has been burned a number of times with changing dates, changing times. And so he would like to have a definite date, definite weekend, a 3-day weekend in stone. These are the times he's going to get her. This is when he returns her because he doesn't want to fly out to Utah and then suddenly be like, I'm sorry, you can't see her today. And we need to have something in stone versus an agreement because it just goes on and months pass.
Notwithstanding, Your Honor, there's some dispute on some of the terminology. We proposed MLK Day weekend. My client is due to give birth. It's a high-risk pregnancy. She is due basically at any point between now and the beginning of January, but her expectation is that it will be an early induction. She sees her doctor twice a week, and So we believe MLK weekend, barring anything unforeseen, would be available, with the idea being it is a regular school day on the Friday, January 12th. That father would get a couple of hours after school on Friday, 2 or 3, return to mother, so that there's some normalcy that first evening after seeing him in person, and then have him Saturday to Monday for basically 2 nights. So we do propose a specific date that's about a month from now. The school schedule is short for the winter holiday. The child doesn't have time off until starting December 22nd, right before Christmas. And given how close we are to that, some concern that there would be both increased costs to the father, but also with the expectation of an early induction, something somewhat urgent or emergent that could cause problems. The MLK Day weekend was the best weekend that appeared to be available, and my client's willing to agree to. There was discussion previously about him having someone else with him, so there was a third party for this first visit, whether it be a family member of his, a paternal grandparent, or aunt or uncle, or a significant other, and I believe that would be agreed. It is accurate that the visits have been on Mondays as part of the child's counseling. My client did propose, I believe, because of the history, father was not agreeable. My client is proposing or asking the court consider moving the visits from during counseling to no longer have them during counseling facilitated by the counselor. Sundays for the next 2 weeks. That would also give him Christmas Eve next Sunday. And as long as there's no issues after those visits, it would go to twice a week via video so that he can continue building the bond with her. So we are agreeable to the in-person visit and actually asking the court consider increasing the frequency and removing the requirement that the visits occur during the counseling session. Of course, previously ordered that the visits are able to be recorded by either parent by the means of the video visit connection. So there shouldn't be any concern on any parent's part. We're just trying to figure out ways to facilitate additional time in the build up to an in-person visit.
And Your Honor, if I may, my client, considering the allegations were about my client, and obviously he's taken the polygraph and done all that stuff, and that the allegations apparently were only to mom. Mom's the only one who said them. Child never disclosed to anybody else aside from mom. My client does not feel comfortable having video visitation at mom's house, where there's nobody there to verify. He would like to continue going to the. Sorry, my phone. Oh, my apologies. It's my mom's number is an emergency. I really apologize for that. Sorry about that. In any event, he doesn't want to have counseling or he doesn't want to have his visitation with the mom there. While they can record the visit, mom can stand off out of sight. That makes it very difficult for him because of the allegations that were already made about him. He is very, very concerned with what might come out from that. He has worked and done everything he's supposed to do. He would just like to see his child. The counselor is really working. He's also able to ask the counselor questions. It's very useful. They're the ones who wanted the counselor to start with. We have that now. We'd like to continue. And then obviously this in-person visit is really important as well. And we would like to agree to that MLK weekend, which is the 15th, I believe, of the 12th through the 15th of January. I think we can agree on that. The first 2 hours after school, absolutely. And then where he returns the child to the counselor. He would like to meet the counselor in person. So the idea was that he was going to return the child to the counselor or pick up the child from the counselor to allow dad to have a little input as well. But essentially, Your Honor's read these pleadings. I mean, my client's been, in his mind, railroaded a bit, and it's been very difficult for him. He's done everything he's supposed to. He's taken the polygraph. He's shown that he's somebody who just essentially lost his child for the space of a year. His family moves, and my client also would like a caveat that if they come back to here, because they come back every single month from Utah to Washington, yet he never gets to see the child during that time. And it seems like it's, why her family gets to see him and my client doesn't when he's the dad, when they're back in this area is a bit upsetting to him. So he'd like an additional couple of hours every time that they're in this area. That seems reasonable.
All right. Thank you, Ms. Winkles. Mr. Baldwin?
Yes, Your Honor. I guess with respect to visits in the state, I think I've heard of that request. I didn't have a chance to discuss with my client whether there's any visits scheduled here in the next month or so. Given her current state pregnancy, I would doubt it. I'd ask the court not to make any other orders, but if the parties are able to coordinate if she and the child are in the state, we can do that. I think my client's trying to move this forward, which is why she's proposing moving to additional time outside the presence of the counselor. There'd be no way for the counselor to facilitate the transition or transfer in Washington as requested. So I don't know how one is okay and the other situation isn't. I will also say, and I don't want to get into the weeds too much, but it's difficult to kind of sit by with the notion or concept that he's being railroaded. We had an agreement. The child saw the counselor expressed concerns. Those were provided to Miss Winkles because of a technical glitch. She didn't receive them immediately. But we have been following the request of the counselor for preparing the child before the video visit started based on their concerns and then beginning them. We are asking and suggesting that the father is making progress such that the supervision is no longer necessary for the video visits at the counselor. I understand his concern and hesitation, but my client's not trying to railroad him or delay him. The only other issue is I can't speak for the counselor's ability to facilitate pickups and drop-offs after school for that first Friday. The child's counseling visits are not on Friday. There's nothing scheduled at that point in time. And I can't encumber them. And I'd suggest the court should not, under the circumstances, require them to facilitate the transfer. If for no other reason, then it creates another roadblock that is unnecessary. My client has family in the area. There are other parties that could conceivably facilitate the transfer if he doesn't want to have her be the one who does it. But again, he's going to have someone with him. I don't see that as being an impediment, but I think it'd be somewhat remiss if I don't suggest that it's not appropriate for the counselor to be the one who the court's ordering when we don't have any indications from them that they're available to do that. And if that's the specific order of the court, it could lead to unintentional delays that we're trying to avoid here. We proposed this weekend, proposed increases in time. I think that's appropriate.
Ms. Winkles, thank you, Mr. Bowman. Ms. Winkles, just a follow-up question. So is your client, would he refuse additional video calls with his child if they were outside the presence of the counselor?
No, of course not. He wants any video visits. His concern is, when I say railroaded, I don't mean when Mr. Baldwin was in this case. I mean, the fact is this is the case, Your Honor, if you remember, where my client was accused of essentially sexual misconduct, where mother did not disclose that her own husband is a registered sex offender. She didn't disclose to the police, to CASA, to this court, to my client, to me, to anybody. It was through my own discovery of putting the names in backwards, frankly, a little dyslexia, that I was able to find that information. That is this case, and that's why he's concerned. He would always take video visits, so he will take them. He'll be happy to record them. He would ask that mom, in that case, if we're going to do that, the mom not be in the room. He absolutely said to record them would be incredibly important. And then to have mom not in the room. And I believe my client's actually chatting with the court. And then also there was one other little thing. Her current counselor does not deal with any court issues because I did ask that she be present today. She doesn't do anything to do with the court. So there is a concern that maybe we do need to get an additional counselor on board for this child, because in any event, this child's been traumatized in one way or another, either through false allegations, through making those fake memories, or through something that happened to her. And it appears that we're not going to have any testimony from the counselor, which is probably one of the most important things, considering the GAL has not even met this child in person.
Okay. Here's what we're going to do. I think it sounds like there's an agreement for the January 12th through the 15th visitation. Here's what I think would be ideal. I'm not going to order the counselor to participate in this process. I completely and totally understand Mr. Webb wanting to meet the counselor while he's there. So if travel arrangements work such that he can pick the child up from school on Friday afternoon, spend a couple hours with her, then if it's possible, then he takes her to the counselor, meets the counselor, and that's the exchange spot, and then picks her up Saturday morning from an agreed upon location. That would just be maybe a good transitional way for the first meeting. If counselor's not available, these parties obviously are going to have to figure out how to deal with this moving forward. So I think everybody agrees that that first night should just be a few hours. So I think pick up from school, assuming he's able to get there at that point. And then back to mom's house, pick up from mom's house Saturday morning, return, I guess, whenever he needs to in time to make a flight out. I don't know if he's going to fly home on Monday or if he'll fly home on Tuesday. My hope would be the parties would be able to work that out. As far as Zoom visitations, I'm fine if they want to continue with a few more at treatment. If treatment wants to move on from that and do something else, then I think hopefully we can get some Zoom calls set up. It sounds like Sundays are being offered for the next several weeks. I think that's a great option. I don't think there's anything wrong with those continue to be recorded. And I think the child is 7 or 8, I believe 7. So I think the child's old enough to be in a room on a Zoom. Mom can be nearby, but I think to allow some private time between the child and father, if those Zoom calls are taking place at home, that doesn't mean mom has to be on a different floor of the house or, but I think allowing her in a room to have those conversations with dad on Zoom are appropriate.
And Your Honor, there's been some changes with the times over and over again, and because of the time there and the time here, it's been very, very confusing. Can we get a set time in Pacific Standard Time where those phone calls can take place?
Did you see if my client made a proposal? Okay. If she entered the time, Your Honor, she and I were back and forth via email as well, and she is here. So if she can unmute and give me a time, my thought was it looked like after dinner before bedtime, so 6 o'clock. Their time zone. Is that right, Ms. Collins?
I was assuming 7 o'clock our time, 6 o'clock his, yours.
Okay, 6 p.m. on Sunday. Perfect.
Okay, Sundays at 6 p.m. If there's a call at treatment or by way of treatment and dad has a heads up about it, that's fine if we want to discontinue that. But if she wants some additional support with treatment, for another visitation, I think we should try to accommodate that as long as dad is aware and knows, when he needs to be available.
Okay.
All right. Anything else?
Just presentation, Your Honor.
Can do the 26th, or you can do this Friday.
I'm available either.
Could we do the 26th, Your Honor? I think that based on the detail of Your Honor's ruling, we should be able to get it entered. Ms. Winkles, if you can give me your proposed, should be able to get entered short of that, but I have a couple other dockets and matters on the 15th, then I'll be kind of jammed.
Does the 26th work for you, Ms. Winkles?
Yeah, I'll make it work.
All right, 26th at 1 p.m. If you get an agreed order in, I'm happy to sign it and strike that.
Yes, the boys and bills should only take a moment, Judge. That's just all for a GAL interim review.
All right.
We were here last week, I recall, and was set over to today's date. We did get Mr. Lawrence's report. I don't think it changes a whole lot about what the current schedule is for this child. So that's about it on our end.
Ms. Winkles, anything to add?
Just on my side, the GL's recommended the parenting plan that we essentially had anyway. It's a phased in. My client knows he has to make up a lot of trust, and he's just going slowly to do that.
All right. Looks like we don't have any other dates set. If there's nothing else, I appreciate you getting that report in, Mr. Lawrence. And any other questions, concerns, or things we need to deal with on that case today?
Nope, we're just in reunification. And so once that moves a little bit further, we'll come back to the court.
All right. Good luck to everybody then. Thank you.
Thank you.
Thank you.
Yes, Your Honor. Noel McLean appearing on behalf of the petitioner, Sherry Sparacino.
Right. And do we have Michael Sparacino?
Yes.
All right. Thank you. All right. So
go ahead.
You go ahead, Ms. McLean. I was just going to summarize what we're here for.
Yeah, I was just going to say, I guess for the record, I don't remember if you did you identify the cause number?
Thank you.
Okay, thanks. So we are here on my client's request for a motion in limine relative to Mr. Sparacino's failure to timely supplement discovery. We have continued to request for updated discovery through his former counsel, and I had filed with the court the documentation, at least the correspondence covered letter that I had received from his former counsel. and then my reply email. There are a ton of items for purposes of our trial that's set the first week of January that I still have not received. So ultimately, and I've listed those in the declaration that was, or both in the declaration and in the email that was filed with the court. I'm missing his 2022 W-2s and 1099s. I'm missing his wage stubs for his current employer, and clearly he has wages that are directly deposited into his bank account. So the expectation is that there would be some type of a record that he can access from his employer. We did not receive any updated Bank of America documentation for account number 3064, and we're currently in the process of trying to get those subpoenaed prior to our trial date. There's 4 different deposits, 2 of which are clearly identified as 401k deposits, which would be violations of the existing court orders, and then 2 other significant deposits that total a little over $25,000 that we also believe are 401k, but they've not responded to our request for a determination of what those are. I've received no updated Red Canoe bank statements from February of 2022 to present. I've received 2 Red Canoe Visa statements, both for February of 2022 and February of 2023. I've received absolutely no disclosure of 2 additional Bank of America accounts, number 8576 and 9706, and there clearly are deposits and withdrawals or transfers between the 2 accounts that he did disclose and those accounts. I have no updated 401k statements, and the screenshot that was provided clearly shows that there's a tab that he can click on for statements and documentation. And previously, he's been able to provide those documents. My suspicion is that he hasn't provided those because he knows that he's withdrawn from those accounts in violation of the court orders. The bank statements also show investing with a firm called Acorn Investing. There's been absolutely no disclosure of that. I requested for updated monthly statements, debt statements, to support his claims for monthly living expenses. He provides absolutely nothing, and yet claims in his monthly expenses that he has installment debts for rent, his vehicle, personal loans, and credit cards. And at this juncture, as I indicated, we are 3 weeks out from a trial date. This case has been pending since 2020. We've previously had to file 2 prior motions to compel discovery because of his failures to comply. And I would note that he has not paid the $1,000 in attorney's fees that are outstanding on those, even though clearly he's had significant income and assets available to him in order to pay those debts. So we're asking the court to limit his testimony and evidence at the time of trial to the submissions that I received earlier, I guess it'd be late last month, November 28th, and that he be precluded from providing any additional evidence beyond those dates since he's not complied with timely supplementing, even though these requests have been out there for several months. Finally, we are asking for a contribution of $750 towards my client's attorney's fees.
All right, thank you. Mr. Sparacino, do you have any response?
Yeah, I'm not withholding any information. There is no 643 account. It never got used to it. They canceled it. I mean, it's not even in my, I don't have it, a 64 account. The 2022, she said, the Red Canoe, those are just, I don't have bank accounts at Red Canoe except for just the debts. So I'm not sure about that. The 8576, not sure what that is. I'll have to look into that. I have no problems giving them everything they want or need. I was trying to talk to my attorney, sent multiple emails and phone calls to ask questions, and I never got the response. That's why I missed that first deadline. And as far as everything else on my internet's kind of spotty, and it's hard for me to do. So I had to go to the bank, or the bookstore to use their Wi-Fi for most of the stuff. And I gave them everything I have. The only thing I can think of, there's hundreds and hundreds of pages I sent as far as the bank accounts. So I don't know why I would miss something, because unless I duplicated something on accident, because I can only do it one at a time. And also, I did send the actual statement of the 401k, so I'm not sure why you don't have that, because I actually sent it, the email with everything else, all the bank accounts and everything. So I'm not certain why you didn't get that. And I didn't know that I couldn't use, I mean, Sherry used her 401k to survive. I'm using it to pay lawyers and to survive myself. So I didn't know I couldn't do that because, you know, the amounts of the amounts, it doesn't, I mean, it doesn't change anything. But I was not aware of that. And now I have no representation. And so I don't know what to do or how to do it. I have to use that money again to hire another lawyer, or hire the same one, or no, I don't know what to do. As far as the bills that I'm paying, again, that's all in Red Canoe. So all the debts I have are Red Canoe. I gave you all that information. And I'm not sure what you think what I'm missing. I mean, you did receive all the Red Canoe information, right? Yeah, because that's the visa and a loan, a personal loan, and then the vehicle. I sent all that information. I have nothing to hide about that kind of stuff. I mean, it's there. So I can resend it or talk to, I don't know, can I even talk to my lawyer anymore since I don't have one? Can I ask for information? Can I do that?
Anything that they have in their file that's regarding you is technically your information. So yeah, they should be able to provide that to you. So, I mean, beyond that, what they're willing to talk to you about, I wouldn't know. But
if Miss McLean can allow me a little bit more time to get whatever information she's missing, if she wants to email me directly with a list, I will absolutely do the best I can to get it to her as quick as possible. I don't think I'm missing anything, but if she says I am, then I obviously am. So I just need her to clarify a list for me, and I will get on that right away. As far as the trial and everything, I would like us to just do another mediation and be done with this. As long as it's fair. I still have to bring information in because I don't know the land in question. We don't know who owns it. Some bank owns it, and somebody's been paying the taxes on it. So I need to get that all straightened out. I got to figure out who owns it. I got to get an attorney to help me with that because it's all messed up.
I guess I would object at this point is this exceeds the scope of the existing motion.
I'm sorry, what?
This exceeds the scope of the existing motion.
I don't understand what that means.
Okay, here's the situation as I see it, Mr. Sparacino. There's a this motion in limine, so that that's essentially a limiting motion that Ms. McLean was filed when you still had counsel. So clearly, even when you were being represented, there were, according to Ms. McLean, large gaps in information that wasn't being shared. We are up against a trial date. Currently, looks like
first week of January.
Yes, we're set for readiness December 26th and trial the week of the 2nd of January. So that is obviously quickly approaching. Whether Ms. Sparacino and Ms. McLean are willing to consider mediation again is not before the court, and that's not really what the request is. I've reviewed the motion in limine. I've reviewed the additional motions to compel. It does appear that there was a significant period of time where you were represented, where there were still issues with discovery in this case. I will say it repeatedly, probably until the day I die. I'm very sympathetic for individuals trying to navigate the legal system without the assistance of an attorney. It can be very overwhelming, very daunting. There's a lot of terminology and rules that need to be complied with that, aren't the easiest to understand, even for attorneys. And so I am sympathetic to that. It does appear that this motion, as I stated, was filed when you had counsel based on issues that counsel wasn't providing things that weren't getting done. We are set, looks like there was previously a mandatory settlement conference that was unsuccessful. That's why we're set for trial at this point. In review of everything, I am going to grant the motion in limine as requested. That does not mean you don't need to provide that information. It just limits the testimony that you can provide about any non-disclosed information at this point or non-disclosed witnesses and that nature. So I'm going to impose that. Based on where we're at, I'm also am going to enter some fees for attorney's fees in the amount of $500.
You'll need to make that change, both that 1A as well as the top of page 2.
And at this point, any requests that you have to potentially seek a secondary mediation or try to resolve the case short of trial, you'll need to discuss with Ms. McLean directly. All right.
I will provide Mr. Sparacino with a confirmed copy of the order by email once it's available on Odyssey.
Perfect. All right.
Thank you.
Good luck. Thank you. Good afternoon.
Representing Mr. Jerry Flowers.
Fernando Ignacio on behalf of Cynthia Blowers.
All right. No more continuances today, huh? We're ready to go?
Yes.
All right. So. Okay. I believe, Mr. Trotter, you filed the initial motion. So I'll start with you.
Yes, Your Honor. So as you know, we're here on a motion to vacate an order that was granted. And, the issues here are that that my client was not personally served when the civil protection order statutes require personal service. In his argument, the other party argues that the civil protection order statutes do not apply to pending family court actions, and the civil protection order statutes in the definition section makes clear that the Superior Court has jurisdiction, or the District Court have jurisdiction over civil protection matters. So, and in particular, specifically, the motion that was filed in this case by his client in the caption states that it includes a request for a restraining order. And so therefore, it also applies for that reason. On the issue of the notice of appearance filed or received by his previous attorney, Mr. Flowers' previous attorney, even that notice of appearance is defective in my opinion for two reasons. One would be that in that notice of appearance, it talks about please direct all papers and pleadings except writs in process. So except orders. So that would be number one. And even if the attorney tried to receive services in the manner that the notice of appearance provides, I would argue that even that would not be appropriate because the attorney cannot circumvent the requirements of the civil protection order statute. These particular issues, there are two issues at play. They're very constitutional and civil liberty issues and that's the reason why the personal service requirement is particularly important in this case. One, my client was asked to leave his home, was removed from his home. And secondly, he was restrained. And there's no basis for the restraining order. And there's no basis for him being removed from a shared residence. My client was in communication with the lender, which was the part of the issue of the trying to get my client out of the home was an argument that the house was in arrears. And so because of that, the other party needed to assert their rights, move in, and get the house out of foreclosure. My client had been in communication with the lender, had submitted paperwork, it's my understanding, and so was moving forward with that process. And because my client did not have an opportunity to be heard, he was asked by the sheriff to leave. I think he's also a vet. He's now living in his truck as a result of being forced out of his home. And so here we would request that my client be given the opportunity to be heard on those two issues again. And then two, ask that he be allowed to go back into his home. Oh, the other request would be was for attorney's fees, and also don't think there would be a basis for providing him with this attorney's fees because the statute wasn't followed. Thank you, Your Honor.
And let me just clarify that. Mr. Anagnostio's request for attorney's fees or your request for attorney's fees?
I'm sorry, Mr. Knopf.
Okay.
For attorney's fees.
That's what I thought. I just wanted to clarify.
Yep.
All right. Thank you very much. Mr. Anagnostio.
Yes, Your Honor, as indicated in my reply brief and documents, absolutely this court has jurisdiction. I mean, the court has plenary jurisdiction over divorce actions pursuant to statute. And then we have case law in Washington that specifically provides that, and I'm talking about the Jones versus Home Care of Washington case, that an adverse party is required to respect the service directions of another party. And so in this case, Mr. Blowers, through his attorney, filed a document that said she was going to be involved in this case, and that all documents, and she put it in bold in her own document, documents to the undersigned counsel should be emailed in lieu of service at physical address. It also indicated how Mr. Blowers was to be served and what email address to use. And so we followed those specific instructions and served Mr. Blowers with a motion for temporary order. The court has jurisdiction. You have jurisdiction over this case. The case was properly filed here. The parties had a marriage here, and they have assets here, and the action was filed here. This is not a void judgment for lack of jurisdiction. At most, I guess it's potentially a voidable judgment, but that's only fact specific. And in this case, the facts are they instructed us how to serve them, and we served them in that manner. And in addition, we served them, pursuant to the standard service process by mail. And Mr. Blowers is not saying he did not get the documents, that he was not served. What he's saying is that, I wasn't personally served, so I don't want to be removed from the house. I want to be put back in the house. And with regards to the equities in this case, my client has spent some $24,000 to get the house out of foreclosure. Mr. Blowers wasn't doing anything. The house was going to be foreclosed on. He was going to be living in his truck anyway, or at least out of the house when they did the foreclosure. She was 20 days or so short of the acceleration clause, where the entire amount would be due, and then thereafter a order gets entered, a sheriff's order removing Mr. Blowers from the property. And so my client, the major asset of the marriage, she spent a lot of money saving that asset, and Mr. Blowers is now coming in and saying, well, I was supposed to be personally served. The court has jurisdiction. And I guess their position is, had we not sought a restraining order that prevents him from having gun rights, he would have no basis to be here. I think that's the issue. They keep raising up and saying, well, I don't have guns, and they're complaining about this order. And from our point of view, it's with regards to guns that Mr. Blowers has. And that's under the restraining order that we obtained, because it gets reported to the sheriff's office. And that's the issue. It's not being removed from the property. Had we, not put that in and just done a motion to remove him, we wouldn't be here. But it's primarily because we, in addition, requested a protection order to my client based on facts that she alleged, as indicated in her declaration, that Mr. Blowers is abusive and threatening to her. So she was asking for a protection order in addition to a temporary order. And they're saying that because this, looks like a action under the civil protection statute, that it needs to be personally served. Even that statute doesn't require personally service. The court can issue orders in advance of getting service based on the facts before the court. And those actions, plenty of case law I provided in my brief, is separate and apart from divorce actions. We're not pursuing an action under that. We're pursuing a motion under a pending dissolution action for a relief. We served Mr. Blowers based on the documents in the file that indicated how we were to serve him. We, in addition, served him under Court Rule 5 by mailing it to him in addition. And yet here we are. To say that another statute somehow controls now a divorce action, from my point of view, it's a frivolous position on Mr. Blowers. My clients had to expend substantial attorney's fees responding to this. There's just simply no basis to say the court didn't have jurisdiction over Mr. Blowers to issue orders. The court absolutely had jurisdiction. To say, so the judgment is not void, potentially it's voidable, but they haven't presented, that's a factual basis. They haven't presented facts as to why it should be voided at this point. So we're asking that the court not grant Mr. Blower's motion, not put him back in the house with my client, that the court deny this motion. And if Mr. Blower's, if there's relief he wants with regards to, gun ownership or those type of things or personal property, we can bring that to court or we can resolve it between the attorneys. But to come in and say, no, I want Mrs. Blower's out of the house and me in it, or it's just it's not a correct position to take. My client's had to incur substantial attorney's fees responding, and we're asking for attorney's fees.
Yes, Mr. Trotter, go ahead.
Yeah, and to the issue of why we're here today, the suggestion that it's frivolous is simply not true. These are very, very important issues. Like I said earlier, is that these are civil liberty and constitutional issues at play, and in particular, those two issues, asking a person to vacate a shared residence and the possession of a firearm, specifically called out by the protection order statutes. Whether or not the court has jurisdiction, perhaps maybe that's not the right way to put it, but in other words, the civil protection order statutes do apply. And then also second to that, they're meant to apply because the motion that was submitted to the court specifically provides that in the caption. It says restraining order. So I don't know how civil protection order statutes would not apply to a restraining order. The other issue being the case mentioned by opposing party, Mr. Natsu, that Jones v. Home Care case. I would say that can be distinguished here because at issue there, I don't know if the issue has to do specifically with the wording of this notice of appearance. As I indicated initially, the notice of appearance provides that please direct all papers and pleadings except writs and process. So even though the attorney further provides way that the service can be received, you can't accept the writ. An order would not be acceptable to send in lieu of service at the physical address. My client did not receive notice via mail or personally served. He's a truck driver and is on the road constantly, and so we wouldn't have known, period. And so that's the reason we're here, is we just want to be heard on those issues. The payments made by the other parties to bring the house into good standing, as Mr. Natsu provides, that's something we can talk about towards settlement, meaning the right to reimbursement, understood. But Mr. Flowers is the owner of this property. He bought this property prior to marriage, and now he's forced out of his home and living in a truck because he was never heard on the issue. Thank you, Your Honor.
One of the things, and this is really to either counsel that may be able to answer. So there was a notice of appearance on behalf of the respondent in this case. Let me see here. Alyssa Miller, and the notice of appearance was filed February 17th, 2023. The agreement for service also filed February 17th, 2023. I see the notice of appearance does indicate documents emailed in lieu of physical service. I do see the accept writs in process portion. Then there is zero withdrawal from that attorney. There's nothing until we get a new notice of appearance by Mr. Trotter on behalf of the respondent. I guess my question is, assuming that we were just dealing with a temporary family law order, which frankly, the court does have the authority to remove someone from the home, require that they not contact someone, not sell anything, not spend any money, not do all sorts of different things. There's a pretty wide breadth of power that RCW 26 allows the court to order as part of a temporary family law order. That was served. So take the protection order out of it. That was properly served the way that the last counsel indicated. So Alyssa Miller was emailed, and then first class mail was sent to the respondent himself, and there was still no response from him. So I guess if the protection order portion, and we're just dealing with a temporary family law order that, let's say, does remove him from the home, where do you see your standing in that situation, Mr. Trotter? Because to me, that essentially the court could do exactly the same thing that restraining order does in a temporary family law order, which wouldn't require personal service, which wouldn't require a lot of the concerns that you have as far as the restraining order goes.
So as to the shared dwelling then in that piece, it sounds like, yeah, so I would say that the law, the civil protection order statutes still apply in that it talks specifically in that statute about personal service being required in those two instances. And so being asked to be removed from a shared dwelling, despite, that's obviously not the restraining order issue, is an issue that I would say is protected by that statute, and therefore personal service is specifically required. It would be my argument.
So if I did grant your request to set aside the temporary restraining order, the temporary family law order, which to be frank, at this point, I haven't seen any basis to change anything that's in that, still requires that Mr. Blowers not be in the home, that Ms. Blowers be able to have the home, and allocates certain resources to either party, certain debts to either party, and restrains certain parties from certain actions. So you still feel that even if that was done in a temporary family law order, there would have been a requirement for a different method of service?
Yes, because of the shared dwelling being an issue.
I guess, Mr. Ignacio, I don't know if you want to weigh in on that, or if you are resting with what you've already stated.
Well, no, it's just not correct. Parties come before the court on a motion all the time, and if the court determines that one party should be out of the home and the other party in the home, I mean, as indicated, you have plenary powers to structure orders around any given circumstances, and so I don't agree that the civil protection order action applies in divorce cases. And I think the court has authority to issue restraining orders as a temporary order. And Your Honor did indicate that you wanted Mr. Blowers served before we had a review hearing, and we did that. Mr. Blowers has never come to court with regards to our actions, and so I don't think there should be any changes to the order, but as far as I can tell, this issue is with regards to gun rights. A lot of the documents that they've proposed that put in gun rights issues raise that. And if the court wants to, remove that prohibition, as long as Mr. Blowers is not coming around the house and is prevented from, and you can do that without a restraining order, then my client is protected, and that's what all she sought in this motion was some temporary protection, temporary relief that the court has authority to issue.
Anything further, Mr. Trotter?
Yeah, I think we're not as concerned. I think our positions are not the firearms piece. That's mentioned quite a bit. For us, it's more of the vacating a shared residence that falls squarely within the requirements of the statute, meaning that personal service is required in that instance as well. I understand and appreciate that Ms. Flowers wanted to get back in the house and make, to get the house in good standing. But at the same time, my client is now living in a truck because personal service, in my position, because personal service wasn't given to him. So had that happened, then maybe we would not be here today and perhaps just settling the issue. Thank you, Your Honor.
Thank you. I appreciate the argument and the motions that were filed and the responses filed. I think it is an interesting perspective on this case. I do agree that I guess I should say with Mr. Anagnostou that there is a wide breadth of authority given to the courts under the family law statutes in Washington. In a temporary family law order, frankly, there's language regularly that is parallel to a lot of restraining order language, that findings could be made about certain things. And so the way I looked at this, read the briefing, read the case law, I do think that the court has the authority to impose a restraining order and do so in a different manner. The last attorney in this case, arguably, I think Mr. Trotter could be correct that there was a carve out for certain service or certain services, certain types of things in that email, agreement to serve by email. And arguably, that could have been something that the court heard, but no one appeared. So not the attorney of record at the time, who was Miss Miller, the attorney at the time. This was noted well before Mr. Trotter became involved in this case. No one appeared on motion, and the court did require ultimately a service on Mr. Blowers, a personal service on him. The information that was provided at the time was sufficient for the court to enter the orders as they did. And I think there's entirely possible Mr. Trotter has found an interesting loophole in this. I, at this point, am siding with Mr. Anagnostou, however, and I believe that the restraining order and the temporary family law order were appropriately entered based on the record that's before the court. I could be proven wrong, and that's totally fine. But based on the information that I have, I think those orders were appropriately entered, and I don't have anything before me at this point to negate those orders.
Thank you, Your Honor.
Right? Do we need a presentation or another review date set in this matter, or do you gentlemen just want to note it up if there's any issue?
Yes, sir. Honestly, you have a.
I'm sorry, I didn't catch what.
Yeah, preference.
Do you want a presentation date, or do you think you can draft agreed orders, or do you need any other dates set or anything at this point?
But before we go on, Your Honor, with regards to the order, is there going to be any award of attorney's fees?
No, I'm not going to award attorney's fees.
All right. That's a simple enough order. I can draft an order and get it to Mr. Trotter, and hopefully we could just sign off on it, that the order, the motion is not granted and no attorney's fees awarded.
All right. And if for some reason that you can't agree on that, then by all means you can note it up. Just so you're both aware, January 1, I'm no longer on Tuesdays. I'll just have presentations on Fridays. So if you need to note it up, you'll be looking for a Friday presentation date starting in 2024.
And I will turn my camera on now.
All right.
Because everybody's
Thank
gone.
you. Good luck.
Thank you, Your Honor.
Except for YouTube video.
Oh, except for YouTube and TikTok, evidently. So,
TikTok.
I got texted a TikTok of this docket with me in it this morning, and evidently I'm not the only one. So, I just want to make sure that I have everything that everybody has. I received an order on hearing from December 5th from Miss Winkles, and then I feel like there was
a declaration from my client came a couple of days later.
And then you have a declaration from my client.
And those were I have those dated the 11th, both of them. Is that correct? Well, at least
mine is dated the 11th, along with my proposed order. I think we received Ms. Winkle on December 8th. So I'm assuming it was filed December 8th, maybe.
Mine might have been filed on the 7th or 8th. Well, let me see. Hold on. I thought they should have been done before that.
I have a supplemental declaration regarding the presentation from Miss White and it is dated 12/8 in Odyssey. And then it looks like there's a motion for reconsideration, which is I would have technically not before me today, but that was filed on the 11th along with the objection to the proposed orders. And then there was a reply declaration
on
the 11th from Miss McLean's office.
That's correct.
And then that's it. Is that okay? All right.
So my clients our proposed orders were filed on December 6th, and that was at 136 CP 136, and then on the 11th, or not on the 11th, I'm sorry, on the 8th, and I think that's where Miss McLean was getting that's when my client filed her declaration. So we had two separate dates. We had the 6th and the 8th, and then Miss McLean got all four of hers on the same day, on the 11th.
Okay.
And you should have a proposed order from me that's a cleanup, assuming you adopt all of my objections.
I don't know that I do.
You should have one that says order on hearing December 5 with my name in the footer. And I signed it this, I'm assuming the 11th, 10th or the 11th. Oh, I may not have signed it. Oh, wait.
I only have an order on December 5th, 2023 hearing from Ms. Winkles. And Madam Clerk, do you don't have any orders in the courtroom with you that didn't get back to, do you?
No, I didn't.
All right.
Okay.
Is that Cheryl in the courtroom?
Yes.
All right. Okay. Thank you, Cheryl.
Do you have the Friday presentation docket this week?
Mm-hmm.
Would that be better, Ms. McLean?
No.
So that you can get, okay. I just wanted to see if you wanted to get your proposal.
No, because I'm in the air on Friday.
Ah, okay.
Okay. So then I guess we'll just work off your objections. Is that
okay? Sure. And then if you decide that you're going to adopt them, I've got an order that is clean that I can ship over.
Okay. And I will work off the order right now just in case you don't adopt them all. And I can send it out via email to everybody.
So basically, throughout, I changed the identification or the identifiers of Mr. to Eric. I changed father to Eric. I changed mother and Mrs. to Rita. I changed child to Benjamin, just so that we're clear as far as who all we're talking about. And then specifically as to finding number 5, the 2 issues as it related to the tax return were not only the Social Security number, but also the job type that also was on that tax return.
Hold on, Ms. McLean.
So
Ms. Winkles, any objection to that first change?
The first one, the changing it to, from Mr. to the name, I don't mind. I don't care either way, to be honest with you. So that works out perfectly. The one about his job, how would you suggest throwing that in there? Or how did you?
Well, if you go back to the tax return that she filed on page 2, it identified him as a biologist. Well, I think wildlife biologist. And the question is whether or not having that, his job identification and his Social Security number in the tax return, whether or not that was potentially a basis for the IRS to suggest that she was claiming.
Yeah, and I have no problem. I mean, I copied this almost verbatim from the transcripts, but it doesn't matter to me as long as I know where to insert it. So Social Security number, inclusion of a Social Security number and job, or in career or job
type.
And job type. Okay.
Well, I'll adopt those first 2.
As it relates to finding number 6, just clarifying that it's parent-directed phone calls only during the winter and summer breaks. And then also that all other video and telephonic contact shall be child-directed, with the custodial parent facilitating the phone calls requested by the child to the other parent. And I believe that that's consistent with your ruling, and also is outlined in the clerk's minutes as it relates to page, this is on page 2, the 6th paragraph.
So I have in my notes that parenting will plan to allow for video chat between non-custodial parent every 3 days minimum during extended summer and holiday breaks. And then if the child requests additional video visits, they should be granted.
If Your Honor will look at number 4 on the orders, that's where it talks about both parents are instructed to facilitate these calls. There shall be no interference. I had that in the, I kind of split up the findings in the, yeah, if you look at order on the order part of it.
Oh, on the order part. Well, that would be those are findings.
Well, they're not findings because they're ordering no interference and facilitation. I mean, it's an order. It's not, I'm finding that, they're arguing. It's, no interference.
So I feel that number 6 in the findings portion. So I guess the findings number 6 on page 2. They all say page 3, but it's page 2. Does reflect. So my notes say that every 3 days minimum during extended summer and holiday breaks. And then if the child wants more, that they should try to accommodate. So
you just indicated extended because we had talked specifically about which one of those holidays were extended, and we talked specifically about winter break. But if that's what your order is, then I would ask that you add in the word extended before holidays, because I mean technically under the temporary order, and I apologize, I didn't grab all of my files. Under the holidays, there's I think there's the typical 3-day weekends, if I recall correctly. I don't anticipate that the court would consider that an extended holiday. Let me pull that
anything that's beyond, I mean, because the normal schedule now is every 3 to 4 days there's an exchange of the child. So anything beyond that time frame. So and so if there's the child is gone for
holidays and summer breaks longer than 3 days.
Well, I mean, the only one that applies to, quite frankly, is summer. I guess technically, no, Easter's a weekend. It's a day visit.
The spring break. Oh, the spring break visitation's longer, isn't it?
Spring break is 5 days.
Yeah.
But not, I mean,
oh, go ahead.
And again, I just object because I literally took the transcripts and just put them in. So these are, I believe these reflect your orders.
And I'm talking about practical application.
And I understand that. So what an extended break wasn't defined. I think any summer or holiday breaks, and my notes say extended summer and holiday breaks, non-custodian parent every 3 days minimum. So let's set any visitation or any, extended summer and holiday breaks would be longer than 5 days.
Longer than 5 days. Okay. Got it.
So you can assume that you'd get at least one contact on a 5-day visit with the child.
And that's parent directed.
Yes. And then if there's any additional, if the child is requesting additional and that can be accommodated, it should be.
Okay. So the 5-day one is parent directed, right? Is that what you said?
Yes. And that's for the extended. Okay. So that's basically defining what extended summer or holiday breaks is, 5 days and up.
Okay. And then if the child wants more, they should accommodate.
So is the court adopting then my language that says all of the video and telephonic contact shall be child directed, with the custodial parent facilitating the phone calls requested by the child to the other parent?
I think that that sounds appropriate. Yes.
Okay. So then on number 7.
Wait, Ms. McLean, where was that real quick so I can pull it across?
Number 6 in her objections.
Okay. I got it. Thank you.
Number 7.
Actually, I apologize. That's number 6 in her proposed order, which is in Odyssey. It's just not before me in real life.
Okay. Sorry.
No, that's okay.
So then, as I understood the ruling and went back through and looked at the clerk's minutes, I was under the understanding that the prerequisite to obtaining the passport was the filing of the bond, or alternatively the $10,000 deposit. And so I guess that's maybe sort of the first rub, is whether or not that was the court's intention with that prerequisite. And then once she complies with that, then he's to obtain. The court did not make specific findings as it relates to evidence about the mother and whatnot. Your inquiry was as to Brazil being a signer on the Hague Treaty Convention. Oops, and it looks like I spelled Hague wrong. I apologize. And then again, the requirement for her to do these 2 things as the precursors. So that's basically the nature of my objections to paragraph 7.
And Your Honor, if I may, I actually took your findings word for word on that when you specifically stated that she, that she had, what did you state? That no substantial evidence suggesting she posed a risk of abducting the child. You noted her long-term residence in the U.S. or ties to the community and her lack of any history indicating a likelihood to violate court orders. And you also talked about the maternal family in Brazil. I took your words exactly word for word in that section. I think that is reasonable because that is exactly what we were talking about during that hearing, is that she has never done anything. And I spoke to the court about that. In order to have findings, 191 findings, there has to be substantial risk, and it can't just be based on a fear. It has to be based on something grounded. It wasn't just the Hague Convention. In fact, we touched very little on that part. It was more to do with the fact of mother herself not having any of the risk factors that would make it likely for her to be somebody who abducts. So I'd ask that my language stay because that was your language.
Again, neither the clerk nor I captured those specific findings. My notes did not capture those specific findings. You had talked about her national origin of the mother being in Brazil. You talked about your belief that she has every intention to come back, which is not one of the factors. We talked about the Hague Convention.
I could actually tell you the minute and second of where it was in the ruling. I don't know if you have access to those audio files.
I haven't ordered one. Did you order one?
Yeah, well, no, I record them because I'm dyslexic, so I have to record. I don't record the conversation. I record I have a transcriptionist type them out in here, and then we do a syncing back. I have the staff. We use like really bad AI, I guess, Otter, and it like can listen to the hearing and it types it out, and then one of the legal assistants will go and fix it. But yeah, we have I believe we do have the CD now, because that's how they fix it back. I did not put anything on TikTok.
I wish I had a better memory of exactly what I said all the time, but I do not. I am going to, I reviewed paragraph number 7. I think I take Ms. Winkle's word that this is the words that came out of my mouth, and I know Ms. McLean disagrees. So I'm gonna adopt this here because I agree with it. I don't think that there's substantial evidence showing that she's a risk. She has been a long-term resident of the United States. Mr. White was aware of her international ties when they began a relationship and got married and chose to have a child. She does not have any history that would indicate that she is going to violate orders. I think also we should note, but I would ask that you note in section 7 that the guardian ad litem weighed in and based on her information that she felt it was appropriate to allow mother to travel with the child as well.
And then the question is about the precursor in regards to the bond or the $10,000.
That we didn't talk about that, the order of things. So
yeah. And that was the thing. So just so you guys are aware, I did again look into a travel bond is for travel agents. So there is, I finally found one though. It's called, I can't even pronounce it. Nay something, it's Latin, a bond. There is one. There is. It's in a different state. I have found one place that may do it here. We have a call into them. I'm not sure if you found any, Ms. McLean.
Nay exit bonds do exist in the state of Washington. There is nobody in the nation that will, from at least our subsequent research, that will issue one for Brazil because they are non-compliant with the Hague. While they are a signer, they have been non-compliant with the Hague Convention Treaty, and they do not interpret the language of the Hague in the way that it's intended to be. There are extended delays for them in trying to find or locate children. There are extended delays based on an interpretation of a 1-year rule that they take longer when they do comply. But typically the judiciary there has not complied. And so that was part of the motion for reconsideration, is the fact that they're one of 8 countries that are non-compliant, but they have historically, apparently and consistently been non-compliant. And if I recall correctly, I think the study from 2023 indicated that there's still, I think, 18 cases that are outstanding of children that have either not been located or not returned despite requests. Currently,
and like I said, I have a call into one, so I should know about that.
Okay, well, my recollection is my first, based on the notes and the minutes that I reviewed, that the travel bond, which is, and I know that we may have gotten confused with a travel agency bond, but the travel bond was the court's preference, and I noted that would because there was still some research and calls out to a location, that would be the court's preference. If that didn't exist, then the secondary would be essentially filing a bond with the court.
And I guess the other question is, now Miss McLean has it as a precondition to obtaining the passport. We have it as a precondition to getting the passport, as in she can apply for the passport now through the US government, but it's going to take weeks and weeks to get it. And in that time, she can go and put the bond in. It just means she doesn't get the passport in hand until she has that, because there's no worry that she's going to steal it if it's in my safe. She's requesting now that it be in my safe or Miss McLean's safe. There's no question she's going to get it. So it shouldn't be before she's able to apply, because the application process is long. And on top of that, they have to get a visa to go to Brazil because he's a US citizen, the child.
So here, my recollection was that we determined that the passport would go to dad.
Yes.
And then dad, if dad wants to give that to Miss McLean for safekeeping. So I know you don't want it, but I think it's probably appropriate for someone other than him to have it, because I'm sure he doesn't want to be accused of not turning it over if it's required at any point. You know what I mean? It's probably just better. And my understanding was, or my recollection, excuse me, was that that's child's primary address. That was what would be utilized. So frankly, I am concerned about the bond issue and the information that Ms. McLean has provided. That's obviously an motion to reconsider that I will address, and Ms. Winkles will have an opportunity to respond to as well.
Yeah.
But I think there's enough layers of safety that we don't have to wait for the bond to be filed before the process can start. So I'm going to say that Ms. White can start the process. Mr. White should aid in that in whatever manner is necessary, knowing that any passport is coming to him. So it's not like that passport's going to go to Miss White and then off she goes. So I think that process can start. The visa application can start, but clearly there's still this bond issue that's being looked into and addressed.
So here's the other potential wrinkle. So my client, and you'll see this in his reply documentation, the parties had pre-agreed that she was going to have, I think, December 10th to December 25th. My client's going to have from December 25th to January 7th for the Christmas break. My client was actually supposed to fly out, I think, yesterday. Right now, my understanding is that he's planning on flying out on his vacation time that he's taken off, that's been planned since July. He's supposed to fly out tomorrow, from what I understood. And now there's been an appointment for this passport on the 14th, which is after he's supposed to fly out.
The appointment's for tomorrow is what I was just told. So the appointment is for tomorrow.
Okay. Do we know what time? Because if my guy's flying out tomorrow.
He doesn't need to be there as long as he signs the forms, though. Is that right? Gets them notarized, the application, because you can mail in those applications as well. He can fill out the notarized form of release. And yeah, you can, there's 2 sections, and as long as it's notarized, you can fill it out and anybody can turn it in. But it has to be a notarized copy. I'm not sure if he has a copy.
Well, forward me what he needs to sign today. I'll get him in here this afternoon. We've got about an hour and 15 minutes.
All right. If he can do that, that would be amazing. I would appreciate it, but I do not expect him to further delay any travel plans that are 6 months out to accommodate this.
How long will he be gone? I'm just concerned because of the visa time and the passport timetable.
If we don't get this done today before tomorrow, then what will happen is that he's back to pick up Benjamin on the 25th.
Oh,
so
okay.
It would have to occur after that, the
okay.
26th, 27th. Although I know that he and his 2 older children and Benjamin also have plans during the Christmas holiday.
She said he can download the form and sign it. Would he be willing to do that?
Well, we can communicate as soon as we're done here.
Okay. Well, unfortunately,
I just need to make sure that I know what the appropriate form is.
Okay.
So okay. So is the court then adopting the language as it relates to the 10th? So I had in there, as far as under findings, and I had added this in at 7, that she shall obtain a travel bond of $100,000 or if unavailable deposit $10,000 with the and technically that should say $10,000 cash. with the Cowlitz County Superior Court clerk to be awarded to Eric if she fails to comply.
And I have a problem with the way that's worded. It fails to fully comply with court orders. I think that's too wishy-washy. That the bond is there for if she kidnaps the child, if she keeps the child too long, if she stays in Brazil longer than she's allowed to by the court. I just don't like the way it's worded because it sounds like quite a draconian thing for something that could be as simple as, she didn't facilitate the call, something of that nature. So I'd ask that it be something more specific, as in if she attempts to take or extend Benjamin's time outside the United States.
And I'm sorry, Ms. McLean, you're referring to the underlined portion on findings on this page 2 of your objection?
Under 7, lines 21 through 26.
Okay, so this is, I'm gonna adopt Ms. McLean's language, but I'm gonna change it a little bit. So, however, Rita White shall obtain a travel bond of $100,000 or, if unavailable, deposit $10,000 with the Cowlitz County Superior Court clerk of the court to be awarded to Eric White if Rita White fails to fully comply with the court orders by returning to the United States at the prearranged time.
And can we add in the word cash after $10,000?
Yes.
United States at the pre-assigned time?
Yes. And I guess if there's a flight delay, Ms. White isn't gonna, if there's an airline issue, and I'm assuming Mr. White wouldn't. This is not because there's a misconnection or a flight issue. This is
because she's kidnapping the child.
Yeah. And then moving into the order, part 1.
Asking to add that it was denied in part and reserved as outlined below.
Ms. Winkles, any problem with that?
No, not with that.
All right.
Number 2, asking to clarify that he can claim the child on his 2022 tax return as a tax dependent.
I have no problem with that.
And then also reserving I guess she does reserve. So on the last sentence at the top of, I think it is a legitimate page 3. The court reserves the 2023 taxes allocation of the child as a tax dependent.
Sure. If you want to add that, a few extra words in there, Ms. Winkles.
Yeah.
All right.
Change the at number 4, change the language to reference the parent directed calls. And now that you've indicated for 5 or longer than 5 days, otherwise child directed calls.
Yeah, I'll just cut and paste from the findings in there as well.
6 just clarifies the identities by name. Number 9, again. Well,
can I? Sorry to interrupt you. I'm gonna under 6 the I'd also I think at this point, understanding that there's a motion to reconsider, also like as an added layer that not only the time frame of the travel, exactly where she intends to be, an address of the location that she's staying, if she's in a hotel, which hotel she's at, if she's staying with family, an address or contact information for those individuals. I think I would want all that information if anybody I knew was traveling internationally, let alone a small child. So I think she needs to be pretty transparent about who and where, and have Mr. White have that information available to him if there's any kind of emergency.
Okay. So she does plan on doing the 3-day phone calls as well, just like
perfect,
because it's an extended trip.
Yes, so that would apply here. But if you could just add in that, contact information and location information where she's staying while she's traveling.
Absolutely.
Sorry, McLean, number 9.
9. Yes. And so I had asked for ranking of priorities as far as bond versus money. And then strike the language about the bond being tied to employment income. Typically, these types of bonds are collateralized with real property or other tangible assets of the individual, and not with income. So I don't want to limit, and that isn't language that the court ordered.
I think that was me Googling it and finding a travel agent bond.
And that's why they do it tied to income, because it's the travel agent for their travel agency.
So are you in agreement with that, Ms. Winkles?
Yeah. Okay. I couldn't figure out, I finally figured out what was going on, but I was a little bit, I couldn't figure out because she doesn't make any money either. So
All right. So if you would adopt that request from Ms. McLean in section 9.
10, 11, and 12 are just clarifying identities. And then on 13, I'm asking that you strike at this time and clarify that the court denied Reader White's request for attorney's fees.
That's fine. You can do that if you want to make that change.
And then I just am asking that reservation language be added for such other activities as support making just inappropriate. Or I'm sorry, yeah.
You cut out a bit there.
Cut out, yeah.
Oh, sorry. Let me put in my others. Okay. Just asking to add the reservation language that in all of the respects not inconsistent with this order, the prior orders shall remain in full force and effect, since this is a supplementation to those orders.
I have no objection to that.
All right.
And I can have that to everybody by tomorrow afternoon. If that's all right.
Ms. McLean, if it looks good and you can work out the kinks and send it to me, I'll happily sign it ex parte and get it filed.
Okay.
All right.
Thank you.
All right. And then I don't think we have any other hearings at this point. And the reconsideration will take that its own path there. I will get rid of this proposed order.
And I was actually going to ask you, both of you, if you'd like a copy of that really poorly AI transcript, but it sounds like if we're doing reconsideration that the transcript goes in anyway, I'd assume. So I didn't know if either one of you wanted it, but nope. All right.
I have access to FTR, so I can
okay.
listen to it again or watch it again. So if Ms. McLean wants it and you want to share it, then by all means, but the court doesn't need it. So
okay.
Thank you.
All right. Thank you. Good luck. And we can go off the record.